You this morning. We were joined on CNBC earlier by Jonathan Cantor at the DOJ. But let's just start off with what are essentially 13 guidelines. Your agencies have been delivering these so-called guidelines, I believe, since 1968. What distinguishes this latest version from the others that we've seen?
Well, first of all, it's so great to be here with you. So as you noted, the agencies have issued guidelines since 1968. Of course, our markets and our economy has changed significantly since then. And so it's been longstanding practice for both the Antitrust Division and the Federal Trade Commission to periodically issue updates and revisions to these guidelines to make sure that they're fully up to date and reflecting the reality of how businesses are pursuing mergers and competing in today's economy, as well as the most up-to-date state of the law.
And what is the process from here? Specific to how does this actually impact the law and the way it is going to be viewed by the judges who ultimately decide whether, when you bring a case, the FTC is correct, or perhaps when they say, as was recently the case, for example, in Microsoft, when they say, no, we don't believe you.
So these guidelines reflect the law. If you look through the document, you'll see a lot of footnotes to appellate court decisions, to Supreme Court decisions. We read through every litigated merger decision that resulted in a decision from the Federal Court of Appeals or the Supreme Court. And so this document is designed to make sure that everybody is on notice about what the state of the law is. And we'll be right now, we put out this draft guidelines. We'll be collecting public comment from 60 days. We're very eager for public input. We got 5,000 comments when we initially were setting off on this. And so we look very closely at that input, and we'll be eager for additional public comments as we look to move forward.
How long is that period of public comment? When do we expect these to be put into actual effect?
So the public comment period is 60 days. So at that point, we will take stock of the input that we've received and remain very open-minded about what things would look like after then. But there's a clear need to be revising the guidelines to make sure that they're fully addressing, the realities of digital markets, the realities of how firms are pursuing M&A in the current environment. And so we'll be keen to get that input.
Yeah, obviously important for our regulators to, as you say, reflect the current reality. But something that is very difficult to do is predict what's coming, particularly in an economy as dynamic as our own. What gives you confidence that these very guidelines you're putting out won't be outdated as a result of changes in the market that seem to occur so quickly?
So I think it's absolutely true that enforcers need to be reviewing the guidelines with an eye to the way in which businesses are pursuing an M&A and the ways in which our economy is actually functioning. We're confident that we've gotten a lot of input, and as part of this process, these guidelines are really addressing some of the key issues that we're seeing across markets. Congress asked us to enforce the merger laws, and that is necessarily a predictive exercise. As a result, the inquiry that we undertake is a risk assessment. We're assessing the risk that a merger may substantially lessen competition or tend to create a monopoly, and that's what Congress has instructed us to do.
My colleague Jim Cramer earlier on our show was talking about, in having read the DOJ guidelines along with your own, that it seemed to him that vertical mergers, for example, under this administration or under these guidelines are something that is verboten, so to speak. How do you respond to that? What is the view overall of vertical mergers, which typically have not received the same level of scrutiny as have horizontal deals?
So look, we will look at every case on a fact-by-fact basis and look at the specific circumstances and make judgments based on the specific facts and law at hand. There is precedent on the books talking about non-horizontal mergers, and so we looked very closely at that. When putting together these guidelines, we noted that historically the courts have recognized a few ways in which vertical mergers can be lessening competition, including by giving a company key control over critical inputs that its rivals depend upon. But that's just one way. There are a whole set of other ways that these types of mergers can risk lessening competition, and the 13 guidelines are intended to really lay all that out very clearly.
Yeah, in the EU, for example, there's a willingness to accept behavioral remedies for a vertical deal. There's a sense here that the FTC will not accept that. Is that the case, or are there situations where you would accept a behavioral remedy, and if not, why not?
Look, we consider every matter on a case-by-case basis. Our obligation is to preserve competition and make sure that mergers are not unlawfully lessening competition. If parties are putting before us remedies or potential packages that they claim would do that, we look at that very closely. But at the end of the day, our job is to protect the public, and we need to make sure that the public is not bearing the risk of a failed remedy. And so, we look at history, we try to make sure we're understanding how previous remedies have worked out to make sure that our approach is fully rigorous and fully protecting the public.
Chair Khan, do you have the resources for increased merger reviews at the same time that litigation is rising?
So another change that we recently proposed would update the information that merging parties have to provide us when they're proposing a merger. And the goal there is to make sure that our agency is able to conduct these investigations much more efficiently and much more effectively, so we don't have to waste time kind of going back and forth, getting information that the parties already have on day one, and that we need in order to be able to make our assessment about whether a deal does or does not raise those concerns. So I'm hopeful that that proposed change, if finalized, will also ensure that we're able to pursue investigations efficiently and effectively, even given limited resources.
Because there are threats of budget cuts, so I am wondering what the resource allocation looks like, and what internally the FTC looks like right now after you've had some significant losses, including the Microsoft Activision one.
We obviously are bringing cases when we think there's a law violation. We've been thrilled that we've had a whole set of success, including with deterrence, which we hear a lot from market participants about the deterrent effect. And as a law enforcer, you always want to be making sure that firms are on clear notice about what could constitute a law violation and are staying far away from that line. We were very grateful to receive a budgetary increase last year. That has enabled us to be growing our ranks. We're still hiring, and we're grateful for those additional resources and the additional work we'll be able to do with them.
Deterrence is obviously very important, but when you do lose, there's questions here specific to Microsoft. You lost in the U.S. court. Why not drop the action from there? Why seeking appeal? Why are you continuing to follow, for example, along with the ALJ proceeding? Chair Khan, earlier, Mr. Cantor sort of said he believes in our judicial system and will abide by judicial decisions. So why would you continue, given the court has already been heard from, with this action?
We fully believe in our robust system of judicial review. I won't be able to comment on any specific matters, but generally, if we get an adverse decision from a district court, we look very closely at it to determine whether we think there were any errors of law or misapplication of law that we think warrant appeal. And so those are the types of assessments that we undertake as we make these decisions. There are a whole set of instances in which the FTC has not moved forward with an appeal, but in instances where it has, sometimes quite successfully, it's always because we believe that there was a misapplication of the law or further clarification of the law that needs to be done. And that's usually what drives those decisions.
Yeah. How much is any of your decision making driven, or at least in part figures into your decision making, what goes on at the EU, for example, or even the CMA? And I ask that question in part because there was a lot of back and forth that would appear based on a Freedom of Information request between the FTC and the CMA involving Microsoft and Activision. Seems somewhat unusual. How much does what they do figure into how you think about what you do?
Look, I was very fortunate to inherit an agency that is seen as a leader globally. During the Bush administration, the FTC launched an Office of International Affairs. And so for over a decade now, the FTC has been entering into cooperation agreements with enforcers around the world. There's been strong support historically from the business community and encouragement for the FTC to be working closely with other enforcers to ensure what some folks call harmonization. So that's the state of affairs. The FTC works closely with other enforcers, but at the end of the day, we make all of our determinations based on the facts and based on U.S. law. We always use our independent judgment when we're making these enforcement decisions.
Why was there a need at all to talk to the CMA about Activision and Microsoft?
So there are various cooperation agreements in place. Again, some of them going back to the Bush administration that lay out appropriate processes. Sometimes it's businesses that want to encourage the FTC to be talking to other enforcers to ensure more streamlined review and more efficient information sharing. So this has been a long-standing practice. I'm grateful that the FTC is viewed as a leader internationally, and all credit goes to our terrific staff of the Office of International Affairs that for many years now has been ensuring that we are sharing our experience and expertise around the world.
You mentioned your staff, and Sarah asked about it as well. I want to reference a letter from what was then the outgoing Commissioner Christine Wilson. She was very critical of you and of what she said was the dissatisfaction amongst the staff. How do you respond to when she says your leadership has led to the departures of many experienced personnel, causing a notable brain drain, and goes on to say pains her to observe the tarnishing of the FTC's reputation and the diminution of its efficacy?
So look, we are fortunate to have consummate professionals, extremely talented staff at the FTC who day after day are fighting to protect Americans from unfair methods of competition or unfair or deceptive practices. Of course, we work hard to make sure that the FTC remains a great place to work. I've been really thrilled that we've been able to recruit a whole set of new folks. We just launched a new Office of Technology. Within a matter of days, we got 600 applications from cutting-edge technologists, data scientists, data engineers who are eager to bring their skills and talents to the FTC. And so we'll look forward to continuing to do that type of outreach and engagement and make sure that we're fully equipped in-house with the skills and talents that we need.
All right, back to the principles that were announced today. One is mergers should not entrench or extend a dominant position. Wondering if you can expand a bit on what exactly that means. There's some people who want to take me back, apparently, to a decision in 1967 at the Supreme Court involving Procter & Gamble, where this theory was outlined. Give us some more sense here as to what that means when you say should not entrench or extend a dominant position.
So there's long-standing case law that seeks to ensure that mergers are not being used to entrench dominance in ways that are basically maintaining a monopoly or creating a market where other firms also have to significantly grow in order to be able to compete. You'll see in the document there is significant citations to case law that really lay out what some of those legal tests and that legal analysis looks like. And so we're going to be faithful to the case law on the books.
Another one that I noted here, a merger is when it's a part of a series of multiple acquisitions, the agencies may examine the whole series. That seems to apply to private equity, for example, which can roll up companies and then combine them. What is your view on that, and how aggressive will you be perhaps in reviewing transactions that in the past did not get perhaps a second request, let alone an objection from the FTC?
So these guidelines are agnostic as to particular business model, but we wanted to make sure we're being clear-eyed about business trends and trends that we've seen in the markets. One trend that we have seen is roll-up strategies, so instances in which a firm will undertake a series of acquisitions, no single one of which may raise legal concerns, but in the aggregate, there can be significant consolidation of a market. And so we wanted to make sure that we were putting folks on notice that those types of instances can warrant legal scrutiny and legal concern. And again, there's precedent, including from the FTC recently, where we have applied scrutiny to those types of roll-up strategies.
You mentioned a few minutes ago that the new guidelines require deals to provide more background information and may lengthen the times. And so I'm wondering how you factor in consumer benefit in that scenario, because any delay or cost could influence the consumer, could harm the consumer, could hurt the economy. Do you think about that?
So absolutely. Congress passed the antitrust laws to promote fair competition and protect the public, including consumers, from unlawful mergers. And so that is a North Star that we follow when undertaking this work. As I noted, the goal of the additional information that we'd be seeking is to make sure that we can pursue our investigations more efficiently and more effectively. And on the back end, that can lead to a more streamlined process.
you've talked in the past about the new way that you're approaching antitrust is designed to perhaps enhance innovation, which you believe may be stifled as a result of the presence of these what we'll call large platforms. Where are we in that effort, and how are we going to see it show itself through some of the actions that you've already taken and that you might take in the future?
So a core pillar of America's economic success, and the reason that we've been able to be the home of so many breakthrough innovations, is the fact that we have promoted free and fair competition and ensured the markets are open, and that if somebody has a good idea and it's popular, that they're able to compete on the merits. And so we're fully confident that if we vigorously and faithfully enforce the antitrust laws, that's going to be best ensuring that we remain a great home for innovation.
Yeah, there are a lot of people who obviously take issue with the positions you've taken, Chair Khan. And there is some question about morale at the agency you run. How do you deal with that? You're attacked regularly. I mean, most people didn't know the name of the FTC chair until you came along. You've taken a fairly high profile, given how high profile you've been. How are you dealing with that? And how would you characterize morale at an agency people I speak to say is not good?
So, look, we are fortunate to have dedicated, committed, talented public servants at the FTC that for years now have been totally out-resourced, especially when they're required to bring lawsuits against some of the most well-resourced companies in our economy. Core to the DNA of the FTC, because we're charged with enforcing the antitrust and the anti-monopoly laws, is sometimes we will be going up against entrenched, very well-resourced interests, and of course, that can provoke certain types of ire, but our North Star is protecting the public, protecting consumers, protecting entrepreneurs, protecting startups. As part of this job, I hear regularly from the business community, including from independent businesses and entrepreneurs and startups. And what they share with me is that one challenge they face is that all too often markets are locked up by incumbents. Incumbents are engaging sometimes in monopolistic or anti-competitive practices in ways that are not enabling them to compete on the merits. And so we want to make sure we're taking that input very seriously, and that informs our work as well.
And finally, what if you keep losing? You lost in Microsoft Activision. You may lose in Amgen Horizon. I know you won't comment specifically on it, but what if the FTC keeps losing in court? What is that going to do in terms of your approach?
So look, again, I've been grateful that we've been able to achieve a whole set of successes, including in the courts. Shortly after I joined, we refiled a lawsuit against Facebook, and last year we survived a motion to dismiss on that, including a whole set of holdings as part of that opinion that really mark a programmatic step forward. At the end of the day, we bring lawsuits when we determine that there is a law violation. Of course, we're going to fight hard and put together the best cases that we can to explain to the courts why there is a law violation there. But ultimately, we follow the mandate that Congress has given us and seek to faithfully discharge our statutory obligations.
Chair Khan, certainly appreciate your taking time with us, and we'll be following the progress of these guidelines closely. Thank you.
Thanks so much for having me.